Good afternoon, everyone, and welcome to our webinar for November. Thank you for joining us today. For those who don't know me, my name is Kate Chalker, and I'm an associate with the firm based in our Sydney office. And our presenter for today will be Adrian Bailey, who is a principal also based in our Sydney office. As you would have seen, the topic that Adrian will be presenting on today is the notional estate provisions as they exist in New South Wales. And so he'll be talking us through the different ways in which they can apply to bring certain assets back within a person's estate for the purposes of a family provision claim. Before I hand over to Adrian, I'll just run through a little bit of housekeeping in case any of you are new to the platform. So first, if you would like to download a copy of today's PowerPoint slides, you can do so by simply clicking on the Files button on the right-hand side of the screen. But if you have any difficulties with that, don't worry, because they will also be included in the feedback email, which will be circulated later today. Also, if you have any questions which come to mind throughout the course of the presentation, please feel free to send them through. You can just click on the chat icon, again, on the right-hand side of the screen, and type your questions in there. Adrian's happy to take questions throughout the webinar or at the end, so feel free to type them in whenever they come to you, and I'll be keeping an eye on those questions and raising those with Adrian when I can. Just to mention that today's webinar will be recorded and also uploaded to our website and our YouTube channel in due course. So just keep that in mind when you're submitting your questions, not to include any confidential information, for example. So without any further ado, I think I'll hand over to Adrian to talk us through the notional estate provisions.
Thank you, Kate, and welcome everyone to this webinar. As Kate mentioned, we're going to be discussing the notional estate orders in New South Wales and their relevance in relation to bringing in assets that we might not have thought would be part of an estate challenge into an estate challenge. So they really turn your traditionally accepted concepts of what is in an estate on their head. So you've probably heard from clients who may be worried about an estate challenge that they've already got the solution for it. And that may be, they might say something to you like, all my assets are in trust. That's not part of the estate. It won't be subject to challenge. Or they might say, I own all of my assets jointly, so they'll automatically pass to the survivor and can't be challenged. Or they might say, I'm going to give away all my assets before my death. Or finally, they might say, the majority of my assets are in superannuation. That's not part of my estate. I'm not concerned about an estate challenged and those assets are safe. All of those statements are not true in New South Wales. And that's because of the operation of the notional estate orders or notional estate provisions within the legislation and its application and the way that the courts have interpreted it. In terms of what we're going to cover today, we're going to have a look through the essential characteristics of the notional estate laws. So have a look at where they can operate and how they operate, scenarios where they might be applicable or we might need to consider them when discussing with clients, strategies for minimising risk, identifying potential issues before they escalate, and then have a look at 4 recent, one of them not so recent, but an important case nonetheless, or 2 of them not so recent. Have a look at some recent cases in the area so we can get an idea of where the attacks might come from and potentially consider our strategies in relation to them. Historically, a widow was eligible for what was known as the widow's share or the dower, which you'd probably recognise it today as a life tenancy in relation to the assets of the deceased husband. Very limited rights other than that historically. In terms of the development to where the law is currently standing, we had the introduction of the Family Provision Act in New South Wales. Prior to that, and after the abolishment of really the concept of the widow's share, people had complete testamentary freedom as to what they did. Family Provision Act brought in the concept of estate challenges, making sure that somebody's adequately provided for. That was later modified or amended, I should say, to include what were then the notional estate provisions. They weren't used a great deal up until we had them introduced or removed from the Family Provision Act, which was repealed and brought into Chapter 3 of the Succession Act. So if you're looking for these sections and how they operate, if you navigate yourself to the Succession Act 2006 and have a look at Chapter 3, that will outline both the estate challenges and the notional estate provisions. In terms of an estate challenge, and this conversation will come up with clients as to whether they're concerned about somebody challenging their estate, because a client will have particular wishes in relation to how they want to distribute it. And as I often say to clients, I'm not the moral arbiter of what you want to do as to whether you should give something to somebody. That's completely your decision. My job is to make sure that if you're going to do that, we can try and make it in a legally effective way and minimise the risk of an estate challenge. We often always say, or we also often say, I should say, that you can't stop an estate challenge. If somebody fits these three elements, then they can still challenge, but you can minimise that risk, or you can make it less attractive for them to challenge. The big issue in New South Wales are the notional estate provisions, because they draw in things that are traditionally not part of the estate into the potential assets that can be distributed under an estate challenge. So if we're going to challenge an estate, we've got three requirements under Section 59. Is the applicant an eligible person? And that should be an as opposed to and. Did the deceased fail to make adequate provision for the proper maintenance, education or advancement in life of the applicant under the will? We often fall into the habit of talking about whether somebody was treated fairly under the will. It's not so much fairness, it's whether they were given adequate provision. And then there's a long list of factors that the court will examine in 59.2 to decide what provision ought to be made for them. So that's how first question, if we're talking to clients, is are they an eligible person? So let's have a look at that in terms of whether they are eligible or not. So in New South Wales, and each state has different provisions. So if you have clients in other states or you're from interstate, those provisions will apply as opposed to New South Wales. So they are all slightly different. We have spouse or de facto spouse, a child, a former spouse, a dependent grandchild or a dependent person who is otherwise a member of the household, or a person who is in a close personal relationship with the deceased at the time of their death, and a member of the household. So there's a couple of different variations of people that could fit in those sort of extended definitions there in terms of dependent person or person in a close personal relationship. I have had scenarios where a foster child, due to the nature of the relationship, was an eligible person. Normally they're not, but they can be, depending on how that relationship develops. And so the first thing is to have a look at, well, is this person an eligible person? If they are, then not much we can do about it, but we need to recognise that there is that risk that if the client does not want to adequately provide for them, in their mind, not our client's mind, that person may challenge the estate. Third dot point there, former spouse. You might have clients think, well, what's a former spouse and why should they get access to my estate under a challenge? Why should I leave them anything? There's a reason that they're a former spouse. So this is somebody who is not separated but divorced. If they're separated, they still fit within the definition of spouse. So you could have the scenario where you have a divorced client, divorced from their first or second or third husband or wife, and they have not reached a financial settlement for the purposes of family court order, because divorce is separate to the financial settlement under the Family Law Act, or they've just chosen never to get one. So that will make that former spouse an eligible person. So many clients will be shocked to hear that, particularly, as I said, if they're on their second or third or fourth marriage, that person could be eligible to challenge. In order to challenge, they must convince the court that circumstances exist that warrant that application. So what the court will look at are some factors which are outlined in Section 62, and that is whether there has been a family law settlement, the length of the relationship, who was at fault in the marriage breakdown, what sort of property settlements they have, what sort of post-marriage contact that they have had. Many family law settlements will have in them a provision that excludes parties from making an application under the Succession Act. If it's not in there, they're not excluded. So bit of a risk area there. If you have clients who have previously been divorced, it's important to work out, one, are they covered in terms of a potential claim from their divorced spouse? And two, what sort of relationship do they have with them, or what are the factors in Section 62 I just went through that may be eligible to make a claim on the estate? So not just enough to think, well, they're divorced, I don't have to worry about them, which many clients do, naturally. Part 3.3 of the Succession Act deals with the notional estate. And very simply, it allows a court to claw back dispositions into the notional estate if they're what are known as a relevant property transaction, and that transaction occurs within a certain time period. If we have a relevant property transaction and that's within that time period, then that property becomes available for distribution under Section 63(5) as part of the estate challenge and as part of the distribution of those assets. So orders can be made against other parties, not in order for that property to be transferred or distributed to the claimant under the notional estate provisions. So we need to know what is a relevant property transaction and what are these time periods. Section 75 tells us what a relevant property transaction is. So there's three key parts. So a person either does, directly or indirectly, or does not do an act. So this is the first real key part that we see in these provisions. It's either something that we do or something that we do not do, which then causes property being held by another person, whether it's trustee or not, or subject to a trust, and full valuable consideration was not given. So there needs to be something that we've done or not done, which causes property to be held by another person and not held by the estate, in essence, or part of the estate. And full valuable consideration hasn't been given for this act or non-act. So if it's the case that we've transferred a property worth $1 million to somebody and they've paid us $1 million, then the transfer of that property itself would not be a relevant property transaction because full valuable consideration has been given. But if, and one of the examples I used of what clients may say to you is, I'm going to transfer everything away, if we're transferring assets to other family members, and perhaps we're doing that under an intergenerational farming transfer exemption for those sorts of assets, so we're dealing with some of the tax issues, we're not receiving consideration normally because it's in essence a gift to that other person. So that property transferred out of our estate will be a relevant property transaction. It comes back to the question of whether it's within the prescribed time period. But that's an example of the sort of things or the sort of strategies that people may think to do, which may not actually get their foot out of the bog. So that's the first key part. You have to have a relevant property transaction. And as we'll see in some of the cases, one of the main things in terms of superannuation is this idea of does or does not do. We have three different time periods that we need to consider within Section 80 of the Succession Act. So that's something that occurred within 3 years prior to the death of the deceased and was entered into with the intention, wholly or partly, of denying or limiting provision of any person being made out of the estate, or it's occurred within 1 year prior to the death and the deceased had a moral obligation to provide for the person which is greater than the obligation to enter into the transaction, or a transaction that took effect or is to take effect on or after death. So when talking to clients, most times when clients come to see us in this area is where they recognise that there is potentially an eligible person, whether it's a child that they haven't had contact with, or a child from a relationship outside of marriage or a previous relationship, and they want to limit the provision that they give to them or completely cut them out altogether. So that's where that 3 year time period is going to apply. Personally, I can't think of scenarios where that couldn't be said to be partly the reason for anything that you do in this world to try and protect against that challenge. So when talking to clients, we always start off with the 3 year time period, saying that anything that we do, you have to live for another 3 years if we're dealing with a transaction involving an individual, or if we're changing trust control, for example, and I'll come back to that. Anything that we do, you've got to live for another 3 years. If we have clients who have a terminal illness of which there is a short time for them left to live, there's no point doing anything from a legal perspective because that will be within that 3-year period. As I said, it will be difficult to think. It's difficult to think of a scenario where you could argue that this wasn't done at least partly to deny provision of the estate. Even when you're arguing it's succession planning within the family, very easy, very low threshold to get across. The other one is moral obligation. So that's occurred within 1 year prior to death, and they had a moral obligation to provide for the person. Moral obligation is really subjective, so it's a question of having a look at the circumstances. Again, I would say if you had a moral obligation and you've done something, you're also going to fit within that 3-year period anyway. Transaction that took effect or is to take effect on death, so that takes into account the sort of suggestions that perhaps we can, binding death benefit nominations, for example, or one, or we have some sort of document that takes into effect on the death of a person. So a transfer of a property subject to the death of somebody. So they will also be within that time period. So just to recap, we have to have a relevant property transaction. So we've done or not done something, which means that in essence, an asset is not part of the estate and it's within that 3-year period. I think that's the safest way to think of it. Before death, then it's going to be very likely subject to notional estate challenge. When we're thinking about it, apart from obviously the first step is going to be whether we have an eligible person, the sort of scenarios where we then need to start thinking about, well, could there be a notional estate order in New South Wales where we have the situation where we have assets which are held in the traditional thinking outside the estate, trusts or companies. So many times I had the discussion with people to say via your wills, you cannot direct assets out of a trust or out of a company. However, they can form part of a notional estate, and those assets can be brought back into the estate for the purposes of an estate challenge. Property held jointly. So many people, if they're in a relationship, will hold their home jointly, so the passes automatically to the survivor. Again, that the failure to sever that joint tenancy so that half forms part of the estate has been found to be a relevant property transaction. So that's that does not do thing. So by not severing it, it doesn't form part of the estate. If we have, that will be something that it's in existence at the time of our death. So jointly held property, whether it's real property or whether it's bank accounts, can be part of a notional estate. Superannuation, again, traditionally thought of outside of the estate, and some of the cases we'll talk about deal with superannuation that can be subject to notional estate. So if we have a client with a large superannuation balance and they have concerns about a challenge to the estate, we need to start addressing that. Or where we've given assets away within that prescribed time period. So, for example, the one I used before, the intergenerational farm transfer. If that's not done for consideration, then that will be potentially part of the notional estate. Strategies for minimising our risk. As I said, we can't stop somebody challenging the estate, but we can minimise the risk of them being successful in doing that. One of them obviously is transferring now, and I'll run through each of these in some subsequent slides and the pros and cons of each, but that would be a relatively simple and straightforward one. We need to look at our existing structures and trusts and companies, and as we'll see, control of the trust really is crucial. And then have a look at superannuation as well, thinking about some of the things that we could do for superannuation to minimise that risk. We also need, and sometimes it's hard for lawyers to think about non-legal solutions because we're always trying to think of things from a legal perspective. But perhaps one of the strategies that we could implement could be the use of life insurance. If it's commercially realistic to get a suitable level of life insurance that can be paid out to a potentially disgruntled beneficiary, then a lot of our issues go away if they're receiving those funds. So that's potentially a solution, a non-legal solution, as I said. Going to depend on costs, and as clients get older, those costs are going to increase. A further non-legal solution may be building up assets outside of our core assets, which go to this beneficiary. Again, using a farming example, if we want one child to take over the farm, maybe we try to build up assets outside of the farm that can go to other children. So they're seen to be dealt with adequately. So again, need to also consider those non-legal strategies, because anytime we can avoid lawyers is a good thing, to be honest, particularly in this world. If we're to transfer assets now, there's some things that we need to consider. So we would want to transfer it to another individual. Choosing that individual, of course, we need to make sure that that person themselves couldn't be subject to challenge if they pass away before us, or an appropriately structured company or trust. Transferring any sort of property, we need to think about tax costs. That's generally going to be stamp duty in relation to real property, and potentially capital gains tax, potentially GST, depending on the nature of the asset that we're transferring. So we need to think of those costs. We also need to think of ongoing costs. So say, for example, we want to transfer a residence to a discretionary trust that's properly structured, and I will go through structuring them from a notional estate provision. But if we transfer it to a discretionary trust, it's residential property in New South Wales, we're going to have land tax costs moving forward. We're going to lose the access to the main residence exemption at the first instance. So we also need to consider those ongoing tax costs. Are they worth the removal of the asset to try and get away in a state challenge? Is the client willing to bear those costs? Timing issues, as I said, realistically, anything that's done needs to be done at least 3 years before the person passes away. Aside from tax costs, and that's immediately what most people will think about, the other thing that we need to think about is the loss of the asset itself. If we're transferring it to another person, or we're transferring it to a trust that we're not in control of, there is the chance that we, as the individual asset owner or the original asset owner, may lose the access of that asset or may lose the benefit of that asset. It may be the case that if we transfer it to a child, 10 years down the track, that child decides they don't like us anymore and deprive us of the use or the benefit of that asset. We need to cover these things off with the client so that they're well aware of that. Usually not an issue, but something to think about as well, pension requirements. If we're transferring assets away, it's a gift. That is, if we're transferring more than $10,000 and the client's receiving the pension, there is the chance, or not the chance, they will lose that pension. Again, normally not an issue with the sort of clients we're dealing with in this world, but something to consider as well. In terms of jointly held property, one strategy may be to transfer our half to the other. Again, we need to think about the other and whether they could be subject to challenge in the same way. But potentially that is a way of doing it at half of the tax cost in a relatively straightforward way. Dealing with existing structures. For trusts, it is all about control. And that's control both at the trustee level and the appointer or principal role or guardian role, whatever role has a power within the trustee to do certain things. Individual trustee, it can't be just our deceased person. It has to be at least one other person. For corporate trustees, best practice, more than one director, more than one shareholder. For appointers, again, can't just be the deceased person. It has to be either them not at all or them with somebody else. Company's slightly different. We have the same sort of analysis in terms of the shareholders. If the shareholder is a deceased person, then that company will be part of the notional estate unless we do something there. But what about, for example, if the company shares are held by a trust, which is not controlled by the deceased person, and there's a sole director or more than one director, if the sole director is the deceased. I'll mention it in the cases, but in essence, what the court have found in those circumstances is that because of the relationship or the fiduciary relationship that the company directors owe to the shareholders under the Corporations Act, they cannot transfer the assets in essence, to the deceased person. So I'll talk about it a bit more in the case, but a little bit clearer with companies, but it is clear that if we have the deceased as the sole shareholder, that company would form part of the notional estate. So we'd need to do something there. Independence, the last point. A lot of our strategies in relation to dealing with existing structures will be to either remove the person entirely. Not many clients will take that step, but some will, from these positions of control, or add somebody else who's independent. Now, this can't be somebody who is independent in name only, because our strategy will not work. They will not be seen to be independent if all they do is rubber stamp whatever the main controller says for them to do. Sometimes it could be a truly independent person, such as an accountant or a lawyer. Again, we need to show the evidence of that independence if we're going to say that this structure is not part of a notional estate. In one of the cases I'll mention, one of the directors was clearly just there in name only, and that was a consideration in relation to that case. So again, independence is important. In terms of that discussion with the client, the reality is you have to say to them, this person has to be willing to go to court and say that they didn't just do what you told them to do, and to show evidence of that, not just self-serving statements. So often the conversation with clients will be the most about who this independent person is if we're looking to changing existing structures. Superannuation, and I will run through them in the cases, but there's been scenarios where a binding death benefit nomination has been found to be a relevant property transaction. And the scenario where we don't have a binding death benefit nomination has been found to be a relevant property transaction. So what can we do? Do we just give up, walk away? Probably not. One of the things, and the things that I've seen in practice and done in practice, is what you might consider to be calling hardwiring the deed. So if we change the rules of our deed so that we can't make a nomination as the member, and the CISA Act doesn't require us to have the ability to make a nomination, and we have in our deed that our benefit will be paid to person X, of course we don't want to pay it into the estate, person X, and that's irrevocable, so it can't be changed. If we made that variation some 3 years prior to the person's death, then arguably that's not a relevant. That payment of that amount is not a relevant property transaction, because we can't do anything as the deceased to change that. It's hardwired, as I said, irrevocable. Of course, then you start thinking about, well, flexibility. What if a person decides in 4 years' time that they don't want to pay that amount to that person? Or what if they die before the person? We're kind of stuck under that deed. Yes, you are. Thinking that through, I guess one solution to that would be to roll it over into another fund. And again, either repeat or have the same process with whoever the new nomination is. But it is something that we could look to doing with clients, again, to minimise that risk of superannuation being part of the notional estate. When we're discussing these issues with clients, whether it's during the planning or afterwards, the potential issues that we want to identify as, is there an eligible person to begin with? Are they being dealt with adequately, or are they perceived to be adequately? What other assets, what are the assets and other structures that could be impacted by an estate challenge? And what are our strategies of non-legal solutions? And working our way through those with the clients so we can see things that potentially could be done to minimise the chance of a notional estate order. So jumping into the cases, and we have 5 cases. I think I said 4 earlier. I obviously forgot one. As I said, 2 of them relatively old. The last 3 not so old. Benz and O'Donnell are in the last couple of years anyway. But very important cases. First of all, Hitchcock and Pratt, going back to 2010. So this deals with Richard Pratt and his estate. When he passed away, clearly it was substantial in terms of his asset holdings and also structuring and all of the different entities he had an interest in. And at the time he was having an affair with Miss Hitchcock, had been a long-running mistress, I guess would be the correct term to use. And so she made a challenge, both in Victoria and in New South Wales. And the challenge in New South Wales was really under the notional estate provisions. So the scenario was that we had real property in New South Wales, which was held by companies. Those companies, the shares of those were held by another company, of which the register was in Victoria. The shares in that company were held by a trust. It was a discretionary trust. Mr. Pratt, he was a resident of Victoria. There's no question about that. That's where his domicile was. As part of, obviously, some planning in terms of, must have been well known that Miss Hitchcock was in a relationship with Mr. Pratt. He and her were excluded from the trust that eventually held the shares in the Victorian company. And although it was clear on the evidence that in essence he controlled that trust. So the argument was that by controlling that trust, he could then force the property to be transferred to himself, and that would form part of the notional estate. The court said no at the end of the day, and there's three key areas of this decision that are important for us when we're thinking about these matters. First of all, in order for an order to be made against us, our domicile has to be in New South Wales. So it's not enough that the assets are in New South Wales, ourselves, the person who is deceased, our domicile has to be in New South Wales. That makes a lot of sense because otherwise, anyone that dies anywhere in the world, if they hold property in New South Wales, could be subject to these provisions. The second part was that comment I made earlier in relation to directors transferring assets. The directors in this situation were not Mr. Pratt, they were independent parties. And the court made the finding in this one that they couldn't transfer the assets to Mr. Pratt because that would be in breach of their fiduciary relationship. The third one was in relation to the trust, and really reinforcing that control of the trust was crucial. Although he was excluded as a beneficiary, he still in essence had control of that trust. But at the end of the day, predominantly because he was not a New South Wales resident, his assets were not made part of any notional estate order. The second case is Wardy and Salia, and this is really where everyone in the estate planning world started to take notice of the notional estate provisions because it really flipped accepted concepts on their head. They'd been there for a while, since 2009 from memory, under the current version, or perhaps 2009. But they hadn't really been used in this fashion up until this stage. So with this case, we had a trust that was established in some time before the deceased's death. Mr. Wardy, he was the sole appointer of the trust. He and his son were the directors of the corporate trustee. He was the shareholder, along with his son, of the corporate trustee. And that trust held 5 properties. Approximately 2 years before his death, clearly the concern about an estate challenge had been raised in discussions. And so he was replaced as the sole appointer of the trust with his son. So we have the situation where he is still the director and shareholder together with his son. He's no longer the sole appointer. His son's now the sole appointer. And under the terms of the deed, the appointee replaced the trustee. And so unfortunately for Mr. Wardy, he passed away within 3 years of replacing himself as the appointer. What the court found in this decision was that the assets of the trust were subject to a notional estate order. So they were part of the notional estate. And what they found was at any time from 3 years to, in essence, 2 years before, since he died 2 years after the replacement of his son, he as the appointer could replace the trustee with himself and distribute all of the assets to himself, ignoring, of course, the tax consequences that would come with that. Because he hadn't done that, so in years 3 to 2 before his death, before he was no longer the appointer, because he hadn't taken those steps, that was a relevant property transaction because it was something that he did not do so that the assets of the trust were in his estate. So the trust, notional estate, assets of the trust, notional estate. The court also found, a little curiously, if you can think of the decision in Hitchcock, that together with his son, he could have transferred the assets while he remained a director as well. But the key point of this one was that he was the sole appointer up until 2 years before his death. So unfortunately for Mr. Wardy, those trust assets were part of the notional estate and subject to challenge. The next one is the estate of Grant, which is 2018 case. There's 2 aspects to this case, one which we're not going to discuss. There was a will that Grant, he was onto his second marriage. There was a will that he'd prepared prior to his second marriage, which didn't state that it was done in anticipation of his marriage. So if you're aware of what happens when you do that is then when you then get married, the act of marriage revokes your will. So you can address that by saying that this will is done in anticipation of marriage to blah, blah. But he didn't in this case, so his will was not valid. So in essence, he died intestate. So one of the arguments over that was whether he was intestate or not, because assets went different ways depending on whether the will was valid or not. He, in essence, given it all to his second wife. The second part was whether the superannuation fund was part of the notional estate. In this case, Mr. Grant had not made a nomination in relation to where his trustee should pay the death benefit. The court found in this case that the failure to make the nomination in relation to the superannuation fund was the relevant property transaction. So that's something he did not do. He could have made a nomination to nominate the fund, the benefit get paid into his estate and then subject to challenge, but he did not. So that was found to be notional estate. Next case is another superannuation fund case. This is one where we have a nomination. So as I said before, whether we have one or not, as we'll see, doesn't make much difference from notional estate provisions. We had the case of Benz and Armstrong in 2022 in the New South Wales Supreme Court. And in that case, the majority of the assets that the client held were actually in the superannuation fund. So there was about 12 million thereabouts in the superannuation fund. He was on to a second relationship, second marriage. And under his estate planning, he had made a number of gifts to the children from his first relationship via his will, a number of cash gifts in essence. However, when it came to administering the will, there wasn't actually any funds in the estate. There were some gifts to his current wife to begin with, and then after that, the children got the belts. Pardon me. But when you looked at what was actually in the estate, because the bulk of it was over in superannuation and that was getting paid to the current wife, there was nothing there to actually pay the gifts to the children. There was lots of evidence in this case that he had intended to pay the children those amounts. Reading between the lines, this looks like a situation where whoever was doing the estate planning didn't realise that the funds were in super in reality and there were no funds to make these gifts out of the estate. And that's an important question that's often overlooked. The client says, I want to give 500,000 to the Cancer Council. Okay, well, where is that 500,000 coming from? Coming from super. Okay, well, that's not part of your estate, not part of your will. If you want it to come from super, we've got to pay your super into your estate. For whatever reason, that wasn't done in this matter. In terms of the challenge, the children obviously challenged because they were relatively upset with the fact that they hadn't received these cash gifts that their father had promised to them. And so the court found the nomination that he made to his current wife deprived the estate of funds. So it was a relevant property transaction and it could be overturned, and the superannuation fund was part of the notional estate orders. Again, ignoring tax consequences, there were some tax consequence submissions to say if it goes to the wife, it's tax-free. If it goes to children, it's not. The court didn't care. They're there to discuss notional estate provisions. The last one to discuss today is O'Donnell and O'Donnell in 2022. And again, this relates to domicile. So we had Mr. O'Donnell, who was born in Goulburn, but effectively lived the majority of his life in the Australian Capital Territory. So his domicile was in the ACT. He did have assets in New South Wales via companies. And those the company assets were around, as the judge said, depended on which submission you accepted, somewhere between 28 to 32 million. His estate itself was a few million, like 3 or 4 million. So he was onto his fourth marriage, Mr. O'Donnell. So clearly he didn't learn after the second or third and decided to go around for the fourth. But one of the reason for the application were for these assets based in New South Wales. So they were held in companies. There was a trust that held the shares in the company. He and his son were directors and other points of control within that trust. He had, prior to his death, in the last few years before his death, he and his fourth wife had bought a unit in Pyrmont, which was held by one of these companies. And a lot of the evidence is about whether he was re-establishing his domicile from the ACT to the Pyrmont residence. If it could be shown that he had done that and his domicile was in New South Wales and the assets of the companies and the trusts were in New South Wales, so a notional estate order could be made. So there was a lot of evidence in this matter given on behalf of the fourth wife and on behalf of the children who were challenging. There was also a challenge from some stepchildren from one of his marriages. But a lot of the evidence revolved around whether he had re-established his domicile in Pyrmont. So the sorts of things they looked at, apart from statements that he was said to have made, were phone records, travel records, all of those sorts of things. What the court eventually found was, despite all of the evidence about some of the statements that he'd made about re-establishing Sydney and Pyrmont as his main residence, it was on the harbour, and I won't say it because this is recorded, but there was something he liked to do off the balcony into the harbour, which he was very proud of, apparently. Because of all of this evidence, the argument was that, well, he's re-established his domicile in New South Wales, or he has a domicile there, so it should be part of notional estate provisions. The court eventually found, after weighing everything up, that his domicile was still in the ACT. So again, an important part there, that if our domicile is outside of New South Wales, even if the assets are in New South Wales, we're going to be safe from a notional estate provision. So an interesting case to read if you want to read all of the evidence of all of the people about where they are planning to live. But key, again, one of the considerations when talking to clients is what's their actual domicile? Are they in New South Wales? And that takes us to the end of the presentation. So, Kate, I don't know whether there has been any questions. I'm just going to turn my microphone off.
No questions for you. So you must have covered the topic very thoroughly.
I would expect nothing less.
All right. So if you do have any questions, you can pop them in the chat now, just as I wrap up, or if anything comes to mind later on, feel free to contact Adrian or I via phone or email. That's no problem. But otherwise, as I mentioned at the start of the webinar, there will be a feedback survey, which will be sent out later today. If you could take a couple of minutes out of your day to complete that survey, we would be very grateful. And just looking forward as we very quickly approach the end of the year, just to let you know, there will be one final webinar for the year that we'll be putting on in December. And in that webinar, we'll be doing a bit of a recap of the year that has been in terms of tax and other legal developments that have occurred. And we'll also be looking at what's likely to be on the cards for 2024. So a bit of a look back on 2023 and a look forward into 2024 and the things that may have an impact on yourselves and your clients into the new year. Sorry, I've just had just a thanks from Brett. Thank you. All right, so if there's no further questions, I think we'll wrap up there. So if you could keep an eye on your emails for that feedback survey, and also when we announce the date of our next webinar, if that topic piques your interest, we'd be very glad to see you there. But otherwise, thanks again for joining, and we hope you enjoy the rest of your week.